And you're welcome back. What I want us to do is to, first of all, hear from the leading figures of the New Patriotic Party challenging the decision of the Speaker or the Clerk of Parliament to go ahead and write to the Electoral Commission for the rerun of the elections in the Kpandai constituency. That includes the 2024 flag bearer of the New Patriotic Party and former Vice President Dr. Mahmoud Bawumia, who's raising concerns as to why he says there's a haste in rerunning the elections. Here's what you missed if you didn't watch highlights of the activities this week. Council, who's right here with us. So I was just going to play that clip of Dr. Mahmoud Bawumia raising concerns about the haste. We'll get that for you shortly so you can effectively listen and then have your take on what's happening. But you've heard the argument that if you look at what's happening, it appears that the Clerk of Parliament is acting in haste because there's some processes underway. Martin Yinam's lawyers are equally asking or trying to seek a review of the decision. In all of this, what do you have to say as a legal team for the NDC side?
I think that it's really say that there's a lot of haste in getting processes underway to have the election rerun. And you are aware that the judgment of the court was for the elections to be rerun in 30 days. Now, the Electoral Commission itself was a party to this case when orders were made and directed at the Electoral Commission. And so, well, I think it's basically down to the orders of the court. The House of Parliament is under some form of procedure, by their own procedure, where there's a vacancy on the floor of the House, Parliament communicates to the Electoral Commission that a particular seat has become vacant. For instance, if a member of Parliament passes away or somebody crisscrosses, Parliament is by duty expected to notify the Electoral Commission. But in this particular instance, we have noticed with disquiet the inertia of the Electoral Commission. Yeah. I mean, if and Parliament itself was initially a party to the suit until it was misjoined. So the orders of the court made were also served on Parliament and the Electoral Commission. So having served the orders on Parliament, Parliament is deemed to be aware, and so I think it was just a matter of procedure. It was proper for Parliament to communicate to the Electoral Commission that we've been served with this order, which order says that the seat has been declared vacant. By extension, Honourable Martin Yindam has been removed by necessary implication, and so an election ought to be rerun. So I think it was just a matter of proper communication.
Last week there was a huge debate here as to whether or not the judge acted out of what was provided for. And while I'm sure he'll be joining us shortly, was making that strong argument that the judge had gone beyond bounds. Then, of course, we had Rashid Tanko bringing us some reliefs you were seeking in court, which was then pointing out to some of the release you were seeking, which included the entire results.
That's so.
Do you honestly feel that, looking at the fact that it was just about 40 constituencies in 14 polling stations, or 44, right?
41.
41 yes. Polling stations that were in contention. Do you honestly feel that, looking at the larger picture, and comparing that to just a minute part of what was happening, it was fair enough for the judge to go ahead and say, well, it affected the entire process, as we're hearing now?
So I would say that, well, it's okay for you to say that if you are not apprised with the issues before the court. I mean, it's not just about contesting 41 polling stations. Yeah. Now, the petitioner went to court alleging breaches of CI 127. Okay. Regulation 32, regulations 39, and regulations 43. You understand? And we intimated to the court a bit forcefully and led evidence to show that the effect of the non-compliance with these provisions had the effect of affecting the conduct of the entire elections and by extension tainted the entire election. So the votes ought to be annulled in elections rerun. Now, let me draw your attention to the justification matter. It was not about votes, if you remember. It was about his eligibility to stand for elections. And that shows that the provisions of the elections are equally as important as the right to vote. You understand? So beyond the breaches, we also alleged breaches in natural justice rights of the petitioner and among other issues. So you see, we asked for a gamut of reliefs, which includes annulling the entire results and then also asking for a rerun. In fact, in there, you would find that at some point, if the court finds it fit, it could order for a recollation. But we have also demonstrated that when the witness of the Electoral Commission took the stance, he indicated that about 93 BVD machines had been destroyed, some ballot boxes. So if we were to do a recollation and a party, per chance, exercises right of objection, we have to go down to the primary materials, you understand? Which materials have been destroyed? Some of them have been destroyed. So I think that, beyond the case we put before the court and we let evidence to show, just opposed with Matthew Nindam's lawyer, Matthew Nindam's case and that of the EC, the judge found favor with our case. Also because like I said, the procedure for conducting elections is equally as important as the votes itself. Exercise. Because if the votes are tainted, you don't really get the right results. Yes.
Okay. Then I recall speaking to Richard Ahiangba this week.
Okay.
He then says, look, even the 30-day provision within the CI, I believe, you missed that. Is that a correct argument?
That is not a correct argument. Now, you would find that the results were published in the Gazette. There's this 6th January 2025 Gazette that has been published by the Electoral Commission. Now, if you do a simple arithmetic and you count from 6th January 2025 to 25th January 2025, you see that we are within the election date.
Okay, so not from the day of the declaration.
No.
At what point when you're doing that, are you supposed to do the calculation? From the day it was declared or from the day you officially received
21 days from the publication of the results in the Gazette. You understand?
No, but if you're told that you are winner of the election, say on December 7th, are you telling me that's not effective?
That's not effective. The rule says, and I can get you the particular provision. I think it is section 18 or so of the People's Representative. So you can only challenge or question the conduct or the results of an election
when you have the official.
When the results have been published in the Gazette, you see. And you would find that the petitioner initial petition was discontinued and another one filed because Matthew Nindam himself filed the 6th January 2025 Gazette in court. You understand? Basically saying that this is the Gazette of the Electoral Commission.
So in other words, that was the document he was working on?
That was a document. So the application was, so there was an application before the court to challenge the petition and have it dismissed, you understand? Now, that will be going to legalese, but the long and short of it is that they produced a document, which document we relied on 6th January 2025. Now, if you count from 6th January 2025 to the date the election petition was filed, that's about 16 days. 16 days? Yes, so we are still within the 21-day window.
Okay, but Dr. Mahmoud Bawumia does not agree with you. He feels that there's some haste here. Okay. Let's listen to him. I think that's ready now. We can take that and then get your thoughts on that as well.
Right now, the Electoral Commission has...
What is going on in our country? It looks like our institutions of democracy and our tenets of democracy are being undermined. The issue of Kpandai with Matthew Nindam is not a new issue in our democratic politics. You've had issues with Dana Bodakpi, you've had issues with Teji Kweston, in Asin, and basically you've had the House allow the court and the legal processes to take place and be exhausted before, state institutions are stampeded into acting in ways that undermine democracy. Matthew Nyundam should be given his day in court. He has filed appeal processes at the High Court. He has filed for a judicial review at the Supreme Court. And none of those cases has been adjudicated. So why the rush? Why the indecent haste? I think that he's being railroaded. I think that this undermines our institutions of democracy. I think that we should take a halt to these processes and allow him to have his day in court, just as others have done in the past. The House has never really rushed in this way when it came to the other cases. What is the difference with the case of Matthew Nyundam? I think it should not be this case. I think we should uphold the tenets of democracy. Democracy is something precious that we've all had and we've all subscribed to. When you start undermining its pillars, you break it down, and the consequences for the nation are very severe. And so simply because you have power, you shouldn't feel that you can ride roughshod over your opponents and over the principles of democracy. And so I stand with the principles that are being espoused by the minority in Parliament, and they're doing a good job at it. And we want to support all the principles that they are fighting over in this particular case. Thank you very much.
Thank you.
Yes.
Good morning.
Okay, so you've heard that. Awal Mohammed is a member of the National Communications team of the NPP. Awal, I want to come to you before I get to the lawyers again. You were here in the studio,
yes,
making claims that it wasn't even part of the relief that the entire result should be announced.
yes.
And today you're facing reality. The lawyer is telling you as part of their reliefs.
Thank you so much, and good morning to our cherished viewers and the audience in studio. When you check the charge sheet that they presented before court, they were seeking the annulment of 41 polling stations. And they said there were anomalies in the 41 polling stations. And that is the basis on which I said that indeed they were not going to seek the annulment of the entire results because they didn't go to court to challenge the entire results. They did not find anything wrong with over 100 polling stations at that time because that collation was done. That is one. Two is that, you see, in our electoral processes, after the elections are done, in the evening, if every polling station is counted, if you win the elections, you know. And if you lose, you also know. And that is right. Because, you see, at the polling station, after declaration, you're given a copy of the pink sheet that you send to your party office. So the lawyer saying that, well, the primary documents were destroyed. Yes, the NDC went on rampage and destroyed the primary documents.
I'm saying to you, but... Okay.
Why won't you allow me at least land? You've asked me a question. So I'm saying that they went on rampage and destroyed the materials at the EC office. But the materials with the NDC and NPP is still intact. If you ask him today, how many votes did Wakpal, what's the name? Did he use to win the elections? He can't mention it. They don't even know. This is more political
is that
than
the
law.
reason why there should be a rerun?
No, I'm saying that this is more political than law because, you see, if there is any contention, I'm saying that Nyundam won with 3,700 votes. If you think you had won the elections, you also tell us the votes difference that you used to win. That's very important.
Oh, wow.
But you're not telling us the vote difference. Now you are telling us that, well, there were problems with 41 polling stations. And you think the 41 polling stations had affected the entire results.
Yes, so it's part of the argument.
It is true that it can affect the entire results. It can affect the 41, can affect the entire results. But we have precedents in this country where when you go challenging polling stations, it is granted. The polling stations are granted and the rest are protected. It happened in Akwatia. 6 polling stations could have changed the results. And they went to court. They won. And Baba Jamal, on the basis of that, became an MP in 2012. So there were precedents in this country where when you go seeking for annulment of a polling station, it is granted. Even the recent one at Ablekuma North. we ran only 19 polling stations. So the reason we're saying that the court did not really give a judgment that we think upholds the rule of law is that the person came to court seeking for annulment of 41 or seeking some problems with the 41 polling station. Why not protect the rest? Tell them to go and rerun the 41.
Okay,
if today he has said that we should go and run the 41.
Let me ask you a hypothetical question. If you're counting a set of 10 and you get to 6, and in that 6 you find that probably it's been inflated,
the rest of
the numbers are not necessarily reflective of what the total number of voters are in constituency 6, are you sure that you get a true outcome of the elections?
No, you didn't give the right scenario. It is not 6 out of 10. 152, 41 out of 152. So over 100 is intact, and they did not find any problem with over 100. They had problems with 41, and they think the 41 will be able to really change the results, and that is
How
true.
will you do an effective tabulation if you don't have 44 intact?
No, I'm saying that is the reason I'm saying that.
Yeah.
The 41 could have changed it because 41 polling stations has over 4,000 votes there. So definitely it could have changed it.
Yes.
So if the court, we were expecting that even if it had won in court, it should be a rerun of 41.
Okay, but
And
on
not
face
really-
value, it wouldn't have been the true picture or outcome of the elections.
I don't understand the question.
Well, you know what I'm saying?
Yes, I don't understand the question.
I'm saying
Yes.
that at that moment, we can all conclude then that it wasn't a true outcome of the entire elections.
So you see, we challenged it and said that both parties have all the original.
No, that's not my question to you, Awal. My question to you is, at that moment then, you don't have the true outcome of the entire elections, do you?
We have the true outcome together with the EC, because the EC gazetted, I'll come with on the Gazette, EC gazetted that he won with 3,700 votes.
Yes.
So that's a true
But I'm saying that you agree that the 44 might be problematic.
So if
at
the
that
41
particular
becomes
moment,
problem,
you agree, Awal,
yes, I agree. I agree that 41 polling stations, you see, all our polling stations, initially it was around 1,000 and so on. It was broke down to like 500. All police stations don't go beyond 500.
I get that.
Some are 600 and so on. So if you put the 41 polling stations together, granted it's even 500, you will get over 4,000.
But I'm saying that you get a distorted outcome of the entire.
That is true. That's what I'm saying.
So if you agree, is that not what the judge is saying?
No, that's what I'm saying. That he could have told us to go and run the 41.
When indeed there's a relief saying it affected the entire results.
Well, I don't know which part of the charge sheet, because I have the charge sheet here. I'll go through and check. Yes, I have the charge sheet.
Because you had the same.
No, I'm saying that I have the charge sheet here.
Yes.
I have the charge sheet here. I'll go through and see where they said the entire results should be nullified. I have not seen that in the charge sheet. To be very honest.
Really?
Okay.
I mean,
so
he's here. He could just.
That is one. Two is that
just land so he
on the Gazette, it's wrong, because the Gazette, it has even been determined by the Supreme Court in the Akwatia case on the 11th of June. When they went to court and we challenged that indeed the Gazette was done on the 24th. That was what we presented to Supreme Court. And they said it was done on the 6th. That is in the case of Akwatia. Then we went to the Supreme Court, and the judgment that came from the Supreme Court says that it is the 24th. That is the original Gazette date, and not the 6th. So that's the reason we are in the Supreme Court.
You're talking about two different things here.
I'm not talking about two different things. He understands what I'm talking about. Because as I stood here, I heard him talk about the Gazette that was done on the 6th.
Which one was Martin Yundam relying on?
You see, it is not about Martin Yundam relying on anything. No, it is about the law. What is the law saying today? That's very important. You may commit a mistake whilst processing your case. That's the reason. Even prosecution, they enter something, they tell you that they are withdrawing to relay it again. So there's nothing wrong with whether Yindam presented the cease or so. There is a Supreme Court ruling, which is a law.
From the perspective of your party, which one was the actual date of the Gazette?
So the actual date of the Gazette, not perspective of a political party.
Yes,
I'm reading from the Supreme Court. I'm reading from the Supreme Court.
Yes.
On the Supreme Court ruling in Akwatia on the 6th of on the 11th of June. He says that just at the tail end of the, that is page 7 of 21 of the
You're talking about two different cases.
I'm not talking about, when I land, you understand it. When I land, you understand it. From the affidavit, I'm coming. From the affidavit record, it was established that the Gazette notification of number 20, dated 24 December 2024 was the valid one. We therefore have no difficulty finding that the results of our Akwatia by-elections were gazetted on the 24th of December. Now, when you come to Akwatia, Yindam,
yes,
that is so Kpandai. Yes. This is the Gazette, and the Gazette is saying that Yindam was gazetted on 24th, and this is on page 8123. Of the Gazette document. So this Gazette is the right Gazette that was sent. So that is the reason we are
sent to who?
That was when you go to the publishing house. That is what has been published.
But Yindam himself is telling you that he's working with the state general document.
Then why did we go to Supreme Court that on the 16th that this one will be adjudicated? You are rather confused. I'm saying that. No, you are rather confused.
Are you saying that in your new case?
Maybe if you stop asking me the questions, he will also give you clarity.
Okay, then.
But I'm saying, let me end.
If you agree that,
let me end.
I'll give you the time again.
Why wouldn't you allow me?
I will allow you, but let him. No,
let me end and tell you that indeed we have filed an appeal.
Yes.
Challenging the results, the outcome of the court in Tamale. We're challenging that. However, the legal team of the party is in Supreme Court saying that even the entire process that happened in Tamale High Court should be declared null and void because of the 24th Gazette.
And you're working with 24th. And I'm saying that before the judge was working with 6.
So I'm saying that the entire process, whether he worked with 6 or 24 for anything, we're saying that the entire process lacks jurisdiction because between the 24th and the 25th that they filed their case, it was beyond the 21 mandatory days of the CI to 27 that we used to run the elections with. Again. That's very important.
Which states were you working?
I mean, before I come to that, I find that a lot of people have difficulties with the matter in question. So this is what the petitioner did. And let me avert your mind to. So Section 6 of the Representation of the People's Act, it says that the validity of an election to Parliament may be questioned only by a petition under Section 17 to 26. Now, it goes on to tell us the relief which may be granted, Section 19. After the hearing of an election petition, the High Court may make any of the following orders. A, declare that the election to which the petition relates is void. B, declare that a candidate other than the member whose election is questioned was duly elected. Or C, dismiss the petition and declare that the member whose election is questioned is duly elected. Now, 20 talks about grounds for cancelling election results. Now, let's take 21B. Now, that there has been a non-compliance with a provision of this act or of the regulation, and that it appears that the election was not conducted in accordance with the principles laid down by law, and that the non-compliance affected the results of the election. Now, just a couple of minutes ago, I have stated that the gravamen of our case is to the non-compliance of the regulations as stipulated in CI 127. I've gone ahead to say that the irregularities and inconsistencies on Form 8A, the pink sheets, for 41 police stations, is to show the prevalence, the extent of the prevalence of the non-compliance in one particular instance. However, Regulation 43 talks about collation. You have to designate a collation center and all that. Now, we are saying that the electoral officer did not have the powers, acted outside his powers when he moved the collation center from the original center to the other place without recourse to our candidate.
So non-compliance was the basis.
It's basically non-compliance with provisions.
But is there no provision for a surgical redress, if I could call it, a more targeted approach?
That is for the court to do. And I've read the reliefs to you. what you need to do is to put your evidence before the court, and we did that. And we showed that, you see, he alleges that the NDC's candidate and the NDC brought tax and destroyed. So the EC made similar allegations and produced video footages. About 8 of them, all 8 video footages were played in court. In nowhere was the NDC candidate or the NDC, supporters seen in that video destroying materials. Now we put it to him, if he could identify Honorable Nsala Wakpa or any of his supporters in that video, he could not substantiate it. It's about evidence. So when you make allegations in court, it will be scrutinized and subjected to strict proof. If you are not able to prove your allegation, what happens to it? It means that the probative value that the court will place on your evidence will be small.
Yeah, but the question about remedy, as to whether or not the judge could have done a more targeted ruling, is that not provided for in this?
So like I said, if you are talking about just 41, you may be misled to go along that time. But that was not the only issue before the court. Like I said, so our client's right of participation was curtailed. He was not allowed to be at the coalition center because he was not communicated to. When the distractions occurred, coalition suspended, and when normalcy resumed, he was not communicated. There's
no official communication
to
from
him.
The Electoral Commission telling.
So neither the candidate nor his representative or any of his counting agents. What it effectively means is that he has been disabled from participation, exercising the right of participation, exercising the right of challenge of any anomaly or irregularity that he feels or is seen to have affected the elections. That is also another material issue that was put before the court. And so it's not just about counting votes. And like I said earlier on, I told you that the right to voting is paramount. It's a constitutional right. The people of Kpandai deserve to have representation. I've also told you that procedure is equally as important. So if the procedure for which you arrive at the result is tainted, it affects the result. And I think there's a more...
Deal with the issue of appeal for me. He's now talking about 2 different, what's the name? The Gazette dates. Yeah.
So they filed an appeal, notice of appeal, and went ahead to file a stay of execution before the High Court. They've also filed a certiorari at the Supreme Court. Those matters have not been determined. Now, so far as those matters have not been determined, the order of the court remains. Now, if the court's judgment were that the elections were not conducted in accordance with laid-down procedure, but did not go further to give further orders, or organize a rerun in 30 days, it will just remain. It will just be a bare declaration that it was not conducted in accordance with the provisions, and then now it behoves on the Electoral Commission to now determine when it sees fit to organize a rerun. But the court went beyond that to give a time frame, 30 days. You understand? Now, you just don't say that, oh, well, I mean, we filed processes in court, so why don't you just wait for those processes to be exhausted?
You feel that must be respected first.
The point is, the lawyers of Matthew Nyenda, Honorable Matthew Nyenda, know that in order to set aside the decision of the court or vary it, you must have your day in court. And that is why they filed an application for stay of execution. The mere filing of an application of a stay of execution before a court does not operate as a stay. So, and I believe you all know, I think they appeared in court on the 10th, and the court will give its ruling on the 18th of December. I mean, they could just have stayed at home and relied on the appeal. But because they knew, and they know, that the orders of the court ought to be complied with, they had to bring an application for stay of execution. So it is one thing having processes in court, and another thing sitting somewhere and preferring an opinion. And I respect the opinion of everybody. Okay. But I'm saying that before the orders of the court will be curtailed or suspended,
you must first of all respect what
you must file the application, go to court, and argue that there are exceptional circumstances for which the court ought to stay its judgment for the appeal to be heard.
Okay, I'll come to the studio audience shortly. Let me get from
Dr. Bawumia said, why the indecent haste by the speaker to declare the seat vacant when there are precedents in this
until there's a change in the ruling.
Because you see, the speaker cannot even declare any seat vacant.
Really?
Yes, he can do that. It is Article 99(1) of the Constitution that says that it is the High Court that is that can declare any seat vacant. But on the charge sheet, I'm coming. He said on the I. You said I, right?
It's a petition.
On the petition, you said I, right? I have it here that in an order of the second and third responded to conduct a rerun of parliamentary elections in the affected 41 polling stations out of 152 polling stations in Kpandai constituency on a date determined by the court.
Which petition do you have?
The one that you have.
What's the date? What's the date of that petition? When was
23rd, 12th, 2020.
So that is not the petition we are talking about.
So which petition again?
So, like I told you,
yes,
the petition for which judgment was given was filed on the 25th.
So this one, you withdrew this one?
We discontinued the earlier petition. No, I mean, I don't understand.
This one was not before court. So what you're reading something else.
This is something that was certified by the court.
But you're reading a straight document.
So that's what I'm saying, that you withdrew this one.
So let me explain to you.
Yeah, but but if it's not before court, why then?
So let me explain to you.
This is what I have.
Okay.
And I think
what you have
signed by the court. That's why you even asked.
Councillor, let me hear from Noah. The whole issue about the timeline, what the provision of the law is. I don't know if you have a take on that. And also, there's the belief that, look, don't rush this because there's another process going on in court. What's your legal perspective on that? The fact that at least there's a standing ruling. Some people say, wait, let's see what happens. Some say you have to respect the initial orders. What do you stand in all of this?
Yeah, so I think I would start by first clarifying something that I think has been lost in the way this issue has been communicated. And I am reading the judgment of the court. And so the parties presented their issues before the court. And when I read the petitioner's issues, I see 3 of them here. I don't think any of them was really about just the 41 polling stations.
Exactly.
The idea is that the petitioner is saying by reason, in some of the issues, by reason of what's happened with the 41, then it may taint the entire election, right? So when a petitioner is asking for that, it requires the court to go beyond the 41 polling stations. It requires the court to delve into the circumstance affecting all the other results in the various polling stations. So in elections, we said there is a difference when the petitioner is seeking a qualitative issue to be determined and when there is a quantitative issue.
Exactly.
So the quantitative is when we are just putting the results together. And say that, well, if we put together and we tally, what is the
You do like a 1 + 2.
Exactly.
Get this.
So in those instances, like he is saying, I think the court could have just said, well, the difference around 3,000. You are just only challenging the 41. Even the 41, when we put together all for you, the petitioner, it won't reach the 3,000. And so by reason of that...
If you go beyond 3,000. If you put 41, it will go beyond.
Yeah, so in those, the court could have just said that, then let's just go and conduct for the 41, yes. Right? Or even maybe we don't even conduct at all if it wouldn't change. Okay. But when the petitioner is challenging the quality of the election, it goes beyond mere counting the votes. It goes beyond, like he mentioned, for instance, whether the person was allowed to participate in the election process, the counting, all of that. And I think if you read the court's judgment, that's what the court had in mind. That because of the alleged irregularities that tainted the elections, it will be impossible to come to a conclusion that those results that we even have for the other polling stations were not affected, possibly in the accounting by the same issue. So I think that's what played in the mind of the court.
Coalition would then come into the picture, which
exactly.
is the entire spectrum of the election.
Exactly. And now, then I'll comment maybe briefly also on the issue you brought up concerning whether there is a haste to conduct the election. And I think we have to look at the constitutional provision on Article 99 carefully. I have always maintained the view that Article 99 gives the High Court the jurisdiction to do 2 important things. Exactly. One of them is to address issues about vacancy in Parliament. And the other is to challenge, when there is a challenge, an issue concerning the validity of an election. Exactly. A lot of times lawyers have commented on this issue and have treated the 2 as the same, but that is not what the draft of the Constitution had in mind. So 99 gives 2 different jurisdictions to the High Court when it comes to matters affecting whether a person is properly an MP in Parliament, right? One of them, which is on the vacancy, is, in my view, what Article 112 addresses. Those may be issues like death occurring when the MP is in Parliament, the MP resigns, or the MP is removed for some misconduct.
Then it will become vacant.
For that, it is Parliament that must communicate to the Electoral Commissioner that because of this person's seat has been declared vacant, and so conduct an election. those circumstances, the EC is not in Parliament. So that is why the EC must be informed administratively by the clerk. But the person whose seat has been declared vacant in Parliament may challenge that decision by the Speaker, for instance. And
because
the High Court...
At that point, it would have been a parliamentary process.
Exactly. Yeah. The High Court can look into that matter and come to the conclusion that Parliament followed the right processes in declaring the seat vacant. That is different from when there is an election petition that goes before the High Court, for the High Court to determine whether the election was validly conducted. In those circumstances, that does not emanate from parliamentary processes, right? And that is why the EC is a party to the suit. So in those circumstances, it does not even fall on Parliament to declare the seat vacant. Immediately the High Court ends the case and declares that that election was not valid, that seat is automatically vacant. So I am even surprised that Parliament is even...
So even a call by the MP saying the Speaker ought to recognize Nyindam for a while until the determination, it doesn't even...
It doesn't even arise at all. And I give an example which I think will help us. If the EC declares a presidential election as invalid, at the time the court would have done that, the person would have been sworn in as president, because by January 7th, the person will be president. So let's say somewhere in February, the Supreme Court declared the president's election as void, invalid. The person cannot continue to be a president. There is nothing like a stay of 7 days to allow the person to respond, nothing like that. From that day, the person ceases to be president, because the court has been given that jurisdiction under here, the High Court, and Article 99, to make that declaration. When the court makes that determination that the person's election is void, the person cannot be accommodated.
But how about precedent? Because some of the parties are pointing to that. That look, it's happened in the past for some other people. What's different now?
No, so speaking about the Constitution, I am of the view that that is not the right process, right? And the fact that it has been done in the past, which I believe is wrong, does not mean it should continue. The proper procedure is laid down in the Constitution. So far as the High Court come to that conclusion, the person cannot be accepted in Parliament. Because who will he be representing? The basis of his presence in Parliament is the election. And that election has been challenged.
So the clerk cannot be faulted for...
No.
For saying...
Properly speaking, like I'm saying, the clerk should not even come in. But the EC is a party to the suit. I'm sure the EC...
They also respect it. And
exactly. That's why the court directed that 30-day to the EC.
We were thinking that there will be an execution first, even if the court had really declared that indeed they should go and write. So we were thinking that there will be an execution of that.
Execution of what exactly? Wow.
There should be maybe the court coming to really notify Parliament that indeed we have declared
the judgment has been made by a court. We all have to respect that, isn't it?
We respect the judgment, as he said. We respected the judgment is the reason we had to go on appeal.
Yeah, but our Parliament has been
seek for stay of execution. And again, have another case in Supreme Court. What we're saying is that because there are precedents in this country where after the court had made declarations of seats and the processes,
well, you just said him
the processes of appeal had started, you don't hear any speaker declaring any seat vacant until the processes are done. We were thinking that let's exhaust all the legal processes.
Is that not giving a human face to it?
No.
As of the point of law.
Precedence is very also important because in the case of Jechi, there were no pending cases in court before the run of the elections. There was no single pending case in court because he lost all the cases in court. So we're hoping that at least let's finish with the legal process. Why the haste in declaring the seat vacant? That is the reason we're saying that it's more political than legal.
Okay, I'll come back to you, but let me go into the audience. Let's get your take on what's happening here.
All right, Blessed, thank you very much for always giving us the opportunity to speak. And I must say that we live in a democratic state, and the beauty of our democracy is that we have a constitution which we must abide by. I think the points the NPP is making in this very case lack legal standing, and so they resort to more of emotional blackmails, and it's even clear from the submission. He said that it lacks legal standing. It is more political than legal, but this is a case of legality. And let me remind Awal of something, that the Constitution is emphatical about this thing. When you check the Court of Appeal amendment, as amended 2022, CI 132, it states categorically that a ruling by a court remains binding unless it is set aside by a higher court. The lawyers are here, they can correct me. And so when the court in Tamale gave their ruling, and the clerk also performs his constitutional mandate by informing the Electoral Commissioner about a vacancy, what the NPP is expecting is that a stay of execution should be granted, but a stay of an appeal in itself does not automatically imply a stay of execution. And if you are saying that you've won by a huge gap, and you are very confident that you have won over 100 and there is no problem with over 100, then what prevents you from going into the election? I believe that it is more democratic of them to go into the election if they believe that truthfully they acquired the legal means to win the previous time. They can still go, because this time around the conditions and factors for which they won the previous time, I believe the constants are still there.
So you're telling Awal that if you're not scared, just go back.
Just go back. I encourage them, because the beauty of our democracy is such that it has to be inclusive and participatory. So they must participate. The grounds are there. The people are waiting. The Kpandai people are waiting. If they truthfully want you to serve them, they will still give you their mandate. But I think Awal is scared because they have realized that they have missed the ball. So the only thing they are implying to now is not to miss the man. And that is why you could see clearly that the minority in parliament, went to parliament the last time strictly to interfere into government business, to make sure that the business of the government doesn't come to play. Just because they do not have a point. They do not have a point. So my point is made and done, and it is straightforward that they should go into the election instead of delaying the processes. And I don't think that they have any legal, if they have any legal approach to state.
At the last check, I'm not sure that the voters register for the Kpandai constituency has been revised. So it will still be the same set of electorates, isn't it?
But general elections are different from just by-elections. By-elections, that should tell you that someone in Accra may not.
But no one is prohibited from voting.
No, you see, the thing is that in a general elections, people check their calendar, they do everything, then they can go and vote in a general elections. That is the reason. I'm coming. That's the reason a lot of people are saying that let's declare the day of elections a holiday so that people can go.
But if you're confident that you would win, why don't you?
I'll address that.
Let me hear you.
I'm reading from 3 News.
Yes.
Dated April 16, 2022. There can't be a by-election in Asindov until final determination of the case. This from the NDC lawyer. In the case of Asindov,
which of the cases are you referring to?
Yeah,
he's talking about
from 3 News.
I get that. I'm just asking in respect of what?
Asindov.
This is not Kpandai.
No, yes. So I'm coming. I'm with the president.
President.
The NDC, with the case of Asindov.
Yeah.
The final decision also came from court.
Yeah.
I don't think he was there, or there was a president in parliament that removed him. The court, his case was in court, and then the court declared his seat vacant. The same way, they said they cannot be a by-election until the final determination of the court. And then we waited for them for everything.
All right. That's
No, this is Ibrahim Amaliba. The legal director of the NDC.
Yeah, but what authority
and now the same thing is happening now. And now the same thing is happening now. And we're also waiting. We also see, let's wait for the determination of the court. The final determination.
There's an ruling by a court, isn't it?
So now, since the lawyer for the lawyer for Honorable Nawal is here, Honorable Insala is here. Council, please, I want to ask your candidate, during the coalition, where were his agents in the coalition? And after the coalition, or after the chaos in the coalition center, did his agent call him that this has happened? And then the EC...
he told you there was no official communication.
No.
I'll give that.
But he will have to understand this.
I get that. Yeah, okay.
I want to know, your agents in the coalition room, did they inform the candidate that the police are moving with the EC to a different place, which we don't know? And I know the police is stakeholder in the election. And the candidate even called the police commander in Kpandai district that this is what's happening. And what's happening. And we want to know all of this. And also, you're having police agents in all the police stations.
Okay.
And I'm sure they brought you the pin sheet for you to do your private coalition.
So you're saying that even if you take the EC out,
I think they have their own pick sheets that they collected their results. So they should be able to tell us the result they had. After everything, what they had.
Okay, I get the point. I get it.
So for that, we don't know. The police, the candidate, was it a deliberate thing?
Yeah.
He knew he was losing, so I have to wait. When party wins, then I come and challenge in court.
Okay.
Because from the way things are going, it's like it sounds deliberate.
Okay.
Like intentionally, because you have an agent there. Your agent didn't tell you that they are moving here.
I get that.
The police commander, you didn't do anything, and they are yet challenging it in court.
Yeah.
It's unfair.
I get that. Just calm down. Don't worry. The lawyer is here. He would answer. Okay. Kamal, I'll come to you after him. Yes. Yeah. Yeah, we're having challenge hearing you. Probably can switch the microphone. Yes, okay, now we can hear you. Yeah. Kamal, you can hand yours over to him. Maybe he would, briefly. And then,
We heard the organizer of the New Patriotic Party, Henry Nanabuachi, said that Ghanaians have regretted voting for the NDC. And if elections were held today, and I have heard Awa said several times, I follow Awa, and he has said several times, I think this is a clear case study. The Kpandai election is a clear case study. If you think that Ghanaians have really regretted upon all what we were put into, the economic quagmire, the turmoil we were plunged into as a people, the misery we went into, and we got a savior to save us, upon everything, if you think that the Ghanaian people have really regretted, this is a clear case study. Allow us to go into the election. You see, Bless, what is happening is that if I were the New Patriotic Party, and I want to say something. He said that the lawyers of the petitioner went to court to seek some reliefs, and the reliefs included the annulment of the 41 polling stations that were affected. But Awal knows that in the wisdom of the court, you can go to court and seek relief, A, B, C. The lawyers are here. But for precedent's sake, the court can add E, F, G, A to even Z to you for precedent's sake. If I'm lying, the lawyers are here. And so even if that is what they went to court to seek, for precedent's sake, and the judges have what we call a substantial effect when they are dealing with a case. What they do is that in the case of Ablekuma, not that they keep referring, the substantial effect compared to Kpandai, what is the substantial effect here? In the Ablekuma North election, it couldn't produce a member of parliament. Now, in the Kpandai election, it was the irregularity where it was able to produce a member of parliament. So that is where the substantial effect lies. Now, you come to this.
So you're saying there can't be any two things?
No. One has been able to produce a member of parliament. The other was not able to produce a member of parliament. So if you are rerunning the 19 polling stations, that is fair, because the substantial effect is not as compared to the Kpandai election, which has been able to produce a fraudulent member of parliament. A fraudulent member of parliament. But maybe this time we should see what is happening. If I were the New Patriots, especially the Nando minority, because they are now shifting from micro.
Okay, let's move.
If I were them, what I would have done is that we would have used the moral suasion instead of, doing this buga way. Because the moral suasion, let me land. Moral suasion is the act of, appealing to the principles of somebody to let them know that what you are doing is bad. It's because the NDC is not doing anything illegal. And so they should know how inconsequential their numbers in parliament is and stop this buga thing and another telling on the floor of parliament and telling somebody, get away.
There are some questions. There's one question to counsel. Counsel, I think there was a question from the individual asking you, the point about communications from the agents to your candidate. Is it the case that there was no communication?
So you see, that's a very simplistic way of looking at it. Before elections actually begin,
I'll come to you.
Before elections actually begin, the Electoral Commission designates, when we start from a rate of election, then there's the notice of election, notice of poll, you pick your nomination forms and all that. Now, there's a designated point where the exhibition, the register is exhibited. You understand? It is designated. You can't change it. It is designated right from that point to the particular polling stations, and it is backed by law. We all know from the start where the coalition will be had. So if there's a disruption during the coalition exercise and it suspends the coalition, now Now, the rule says that where there's a disruption at the polling center and there's a disruption, now the presiding officer there can suspend the elections at that point for a day. And then if after a day normalcy is not restored, I mean, there's another period designated. But when it comes to the coalition center, the law does not expressly say that you can designate, change it on your own. We are saying that since the law provides that you can suspend it and come back to that same venue at a designated time, that is what should have happened there. So if you intend to change it, there must be a formal communication
and not just to you, but to everyone to say,
exactly.
This is where
this is when validate the results. Hold on. It doesn't, even if you change, it doesn't, because when you check 2013, the Supreme Court ruling.
So, you know,
but he's saying
so,
that then. Okay,
so, like I said, we went to court stating and alleging a number of infractions with the provisions, you understand? And this is one of them. So we are saying that if you intend to change the coalition center, there's a procedure. You don't just do it so much and say that, well, anyway, for whatever reason, you had intelligence, you picked intel from the national security, and that is all well and good.
Give me one? I'll give you the chance. Let me just finish. I'll give you the opportunity.
You have to communicate to the parties involved. Now, when there's a disruption and we suspend proceedings here, because of the nature of the fight, we may probably scatter all about. If you resume recoalition, you have to call everybody in before you start, because I am entitled to be at that coalition center. Now, when I come here and the program has been moved to another venue, how am I supposed to know if you have not communicated to me? So what we are saying is that it's not about just common sense, it's about following the procedure. The Electoral Commission is bound by law to conduct elections according to a particular procedure and regulation. And so...
hold on, let him land. He's answering your question, so let him land.
The question and the answers are...
but you can't force him to give you what you want. He's telling you what I'm trying
to tell him.
So let's listen to his response then. Just hold on. Okay, guys. Allow him to. Please, let him answer. Yeah, it's fine. Okay, let him answer. I'll give you all the opportunity. Yeah, so let him answer. So hold on. Let him answer. I'll come back to you. Yes. Okay, guys. Yeah, I'll come back to you. Yeah, I'll come back to you. It's okay. Yeah, it's okay. Just calm down. I'll come back to you. It's okay. Calm down. Yes.
So what I'm trying to say.
It's okay, guys. Yes. Let's listen. Yeah, let's listen. I'll come back to you. Just hold on. Yes.
Let me use this analogy. What I'm trying to say is that. So let's use the Ghana Premier League.
Yes.
We know when a particular team is playing another team and which venue right from the start.
Yes.
So let's say you are supposed to play Hearts of Oak.
Yes.
On the 20th of December at Accra Sports Stadium. You produce yourself at the stadium.
Yes.
Hearts of Oak does not show up. The referees don't show up. And instead, they go to the Tema Stadium and say that you didn't come, you didn't produce yourself, so you lost 3 points. You understand?
Yeah.
You didn't show up at the venue, so you've lost 3 points. They expect that when we got there, we saw a snake at the entrance, so we moved to Tema Sports Stadium. We expect that you should know and come. That is not what happens. There must be formal communication that because of A, B, C, D, we have moved the venue. Okay. Because you see, and I've told you that by moving the venue, you have disabled him from exercising his right of participation and even his rights as far as even challenging the results, as far as even asking for a recount. All those possibilities can arise.
Okay, because we're pressed for time, let's be very snappy so we can talk about the OSP issue, because that's also another one on the agenda.
I think my colleague here made mention of Ablekumanov.
Yes.
When he was citing an example. The mistake here is that for Ablekumanov, the court gave an express order for the Electoral Commission to go and declare the results when 3 were outstanding. So you should get it. The 19 rerun was not a court order. Yeah. It was an EC's order. So let's put that one aside. But Blessed, I'm surprised you are joining people to say, if you are confident of winning, why not go?
I'm not joining.
I'm surprised because you are not supposed to play such a devil's advocate.
Oh, really?
In that, if we want to go by that tangent, many parliamentarians will have to go for rerun again. Because I can decide today, or another person can, please, when you spoke.
Yeah, so allow him to land,
please.
and then I'll give you all the opportunity. Just come down, yes.
Somebody can equally win an election by, say, a margin of 50,000, and another person can challenge the results, and you tell the person, if you are confident, just go.
Go and where
is this done? So we shouldn't let that.
But is it not a fair question to ask?
It isn't.
That if the court says
because
you didn't follow procedure.
Because if you want to be going by that, and there will be chaos. Many people will petition against it, and the only answer people or the suggestion people say, if you know you can, we just go for the rerun. Where is this done before? Now.
Yeah, but I'm saying that it's not a fair question to ask.
It isn't to me.
Look, a court has made an order. You disagree. It's becoming a very prolonged exercise. You have a shorter route as maybe member of parliament who has legitimacy in the constituency. That look, when elections are held today, the same set of people will be the ones going into the elections. That's why I'm asking the question. Is it not fair to just
if you are dealt with unfairly, another person tells you that you can still go back because if you are sure that you win, why have qualms about the election? Yeah. That's what I'm saying, that let's put that aside because I totally disagree with you on that. You see, you asked counsel about the gazetted results, and he's beat about the bush. It's not straightforward. The official Gazette report was done on the 24th. This is a Ghana News Agency. EC Gazette's 274 parliamentary election results. 2 constituencies outstanding, which is...
Are you talking about the presidential or the parliamentary?
Both. The parliamentary. In fact, parliamentary. Here, it's parliamentary. Let me go over. EC Gazette's 274 parliamentary election results. 2 constituencies outstanding. The 2 constituencies were Dome Kwabena and Ablekumanov. So they were gazetted. We should just get it straight, regardless of whatever somebody took it. The official one.
Do you know why I'm asking you the question?
Official one, the official gazetted report here is that what was gazetted.
Yeah, but do you know why I'm asking that question? Well, because I'll give you the opportunity. But the reason why I'm asking you for clarity is that at the parliamentary level, the returning officer, I need some education on this, is different from the presidential, right? And so when the process is completed, I think I covered Dome Kwabena. After the exercise, you officially have them, they're supposed to paste at the center, and then later on, declare and all of that.
Submit to the region. He will submit to the region. The region will submit to the national. Then they will submit to Assembly Press for it to be gazetted. Okay. So that's what is.
That's why I'm asking that.
The finality of your question, the answer I'm giving you is that the official report here is that it was gazetted on 24th December. That's it.
So how come Martin Yendam was relying on that?
I said it's the official one. That's the remedy we are seeking for at the Supreme Court. So don't worry. Hold your horse. Now, you see, when it comes to declaring seats vacant, and then the determination must be done. In this case, we have cases in court, and we are saying that the Speaker should have held on to declaring the seat vacant, because if you look at what I have here, that is a graphic online, 31st October 2024. The Speaker of Parliament, Agban Sumana Kingsford Bagby, has failed to have the decision by the Supreme Court suspending his declaration of 4 seats in Parliament vacant reversed. Now, a part of the story, the import of the ruling by the Apex Court is that 4 members of Parliament whose seats were declared vacant by the Speaker, that is Cynthia Mamle Morrison, I don't want to go, will continue to be MPs pending final determination of a suit by the majority leader in Parliament. Pending. In this case, there are cases pending. So you just hold on, let the courts determine all these issues. And I was happy when I was stressed the point that by the time Honorable Jeji Kwesing's rerun was to take place, there were no pending court cases. And that is what should have sufficed that.
Should the Parliament of Ghana respect a court ruling?
But they can't disobey a court ruling.
They can't disobey. So if the court says that by December 30 or in 30 days, organize fresh elections, would you obey that first before doing an appeal?
But in this case, upon that, the disgruntled party person here has also gone to another higher court.
Would you respect the first order? Because you can't come to equity without
what?
Clean hands, right? If you have to first of all.
But in this case, it is the equity that has made him to go for an appeal. Is that not equity? He's not satisfied with the decision of a high court. And he's gone to the appellate court. And the party has also gone to the Supreme Court.
All right.
So let us, but you see, lastly, that's why you were interjecting me. I wasn't, because you talk of time. Lastly, let's look at what transpired in 2013. some of the things council sat here and enumerated. Atuguba and Co told us that transpositional errors, the absence of a candidate to be there, not to be at the center, not signing, all those things do not invalidate
the results.
Those who have voted, you see, the 100 and something polling stations, now what they are suffering this consequence when their issue is not in contention.
All right, I get
now you are making them come back to come and vote again.
Okay, so here's what I'll do. Let me just take the final thoughts of you guys, and then we take a short break and deal with the OSP issue. I'll come back to you.
So you see,
briefly,
what my brother here said is rational.
Yeah, I think let's listen to a while. Let's listen to a while, and then I'll get back to you guys. Yes.
Okay, so what my brother said here is rational. After the elections is conducted, after declaration at the polling station is done, they all move to the collation center with their with the ballot boxes with clips from the parties. The parties will have to put their clip on every ballot box. Then it is sent to the collation center. Sealed. You understand? It is sealed. Then it's sent to the collation center. If there are any disruption, we follow. Wherever the EC is sending it, the parties follow. So you are telling us, I'm coming. He said he's not really a political agent, right?
Yeah,
he's a lawyer. But I'm saying that. What happens at the polling station, at the collation center, when there are disruptions? In Senate West in 2024, there were disruptions like this. The parties followed everything to Techimai. And Baba Jamal, I'm coming.
Legality.
The legality is that there is no way you will leave that ballot box with the EC alone and police to send it somewhere. It doesn't happen anywhere.
But you have a place.
You were reporting at Gwami Kwamia, you said.
I did, yes.
Didn't you see the parties following in the pickup, holding the ballot boxes to wherever it is sent?
Yeah, but it came to one
and
center.
I'm telling you that
it was at the center.
It was at the center in Senate West in 2020. Yes. In 2020, in Senate West, there were disruptions like this. Some about 10 or 11 polling stations, just like this. Then they took it. The parties followed to Techimai. Baba Jamal, director legal at that time, went and added his clip to it until the court determined and it was opened and counted. So for you to tell us that after they changed the venue, you didn't even follow. You didn't.
Yeah, but he's saying that's not what the law says.
It is not true.
All right, okay.
It is not true that they didn't follow. Okay, no. That is one. Two is that when you tell us that, because of when we're told that, well, if you think you can win, why don't you go and run? I told you even last 2 weeks when I came here that this is a seat that belongs to the NDC from 92. We've never won the presidential before. Right. But Yindam came in 2012 and won with about 2,000 margin. In 2016, he won again. In 2020, he lost and didn't really protest. Went back, sat and worked, and now he got the highest margin of 3,700. And yesterday, my general secretary, lawyer Justin Kodia Frimpong, also on Asempa, and he told you that we are following the court processes. We will do all the court processes.
So why are you picking and choosing the court processes?
If the court declares that indeed we should go and run, we'll go and contest.
But the court, there's an existing court order asking you to
I'm saying that we respect that existing court order. That is the reason we are on appeal and we are in the Supreme Court.
So until then,
if we are able to exhaust it, and this one will be exhausted by 18th. Okay. By 18th, I'm sure by 16th, because the first one is on the 16th, which is the Supreme Court. And I'm upbeat that with the date of Gazette and the date that they filed, it will even declare the entire process at Tamale High Court null and void. So the 18th will not be necessary.
No, I don't know if you have any take on the Gazette issue as well. The time.
Yeah. So I think what I have is basically a question and an answer, right? Gazettes publications can be changed by the same person who gazetted, right? So if the EC gazetted about 274 constituencies, my question is, at that time, were the 41 polling stations results added to it?
Yeah, it was added.
It was added. Right.
That was the reason they had to gazette.
But now if it's been annulled...
Yeah, so exactly. So at the time that the EC gazetted those 274, because I think I've heard the FM report say something to the effect that there were subsequent re-gazetting of some of the results.
So that is what they used. on the 6th.
So it is true that there were some
but you
regazettes.
see,
So you're making his point then, that it could be changed.
On Kpandai,
the Gazette could be changed.
The Gazette is on the 24th. That is what Kpandai's, that is what was done in Kpandai on the 24th of December. Not initially, the entire Gazette.
So there wasn't any re-gazette.
There was a challenge. No, there was a challenge that there was a re-gazette on the 6th, which they used to challenge the Akwatia seats. On the 11th of June this year, the Supreme Court ruled that the 24th Gazette is the right Gazette and not the on the 6th. And they used on the 6th to challenge the process. That is the reason I'm saying that the case will terminate on the 16th because the Supreme Court will upheld it.
So I think for me that's the question I
Okay, anyway, let's wait and see. Yeah, okay, counsel, just land for me and then I come to we hear from
you see there are matters, there are legal matters and there are opinions.
Yeah, right.
So let me just say that the orders of the court is for a rerun in 30 days.
Right.
Now let's take the Jackie matter. Did the court order a rerun in 30 days? If the order of the court is that you were not eligible to have stood as a candidate in the elections, and then so therefore goes ahead to annul the results and says that there must be a rerun, there was no time frame.
No,
let me finish.
Let him land.
The Constitution.
Let me finish.
But let him land.
There is a time frame. The Constitution of Ghana is saying that if the court
can I finish?
I'm coming.
Can I finish what I'm saying? No, I don't need your help.
He's also.
I don't need your help.
So let him land.
I don't need your help. So I'm trying to explain.
Ask whether there is a time frame in.
Allow him.
There is a time frame.
Okay, but allow him to.
In the order.
Yes.
If the, you don't need let me finish.
Allow him. Just allow him to land, and then we'll make progress. Yes. Yeah.
I'm saying that in this particular instance, a court of competent jurisdiction has added a time frame. Do it in 30. Do it in 30 days. You understand what I'm trying to say?
Yes.
Have the rerun in 30 days. So until that order is set aside, that remains the binding decision of a court. If you want to set it aside, you file process, and that's what the Honorable Martin Indian's legal team has done. They filed a stay of execution. Wonderful. They filed processes in the Supreme Court session. I have restrained myself from talking about the matters before, or that will come up before the Supreme Court, because, I mean,
it won't be proper.
It won't be proper to go into details. Otherwise, we'll prejudice the matter before. But I'm just trying to say that if the legal team of Honorable Martin Indian are successful in staying the execution of the court,
then we abide by that.
Of course, because there are legal processes that ought to be followed for everything to be done. I can't just get up today and say that I've decided that the elections must go on, and so therefore I go and railroad everybody to get the elections done. It must be done in accordance with the orders of the court, and that's what is being done.
Okay.
So if they're able to succeed in the stay of execution, all the better. I mean, if they are not successful, there are other processes that they can use.
Yeah, I get that.
So I think.
Okay.
So, but I'm saying that, in the case of Jetchikwesin, if there is a ruling from...
Okay, let's do the special prosecutor now.
If there is a ruling from a high court declaring a seat vacant, the Article 1125 of the Constitution is saying that it should be rerun within 30 days. In the case of death, it is 60 days. You understand? So the Jetchikwesin one, you don't need any consequential orders from the court to tell you that do it within 30 days. The rule is that within 30 days it should be done because the court has declared. That's the Constitution.
Okay, so you're agreeing with the one. Okay, anyway.